Apartment Owners Association of California. It's great to have you with us today, and you're going to love who we have in the house as well. And he's going to bring you the the 2179 lowdown. And it's so great. And then we have Michael Brennan today. Oh, let the cat out of the bag. But, you know, there's differences of opinion, and you see that obviously at the Supreme Court level. And so I just want to throw that out there, that there are differences in the way that people are looking at things. There's aggressive approaches, there's conservative approaches, and you, as a housing provider, get to choose which way you want to go and what you want to do. And so we'd love to just get it out there for you. So very excited to have this live stream for you today. And so yeah, if you missed that one, then also the other one that we had last week that was really great was from a representative from the Housing is Key program. And she shared kind of what the timeline will look like if you've been approved, or what it's going to look like getting your case assigned and either getting accepted or denied. And so you could go back to last week's and check that out. And the way you can do it is go to AOA, or no, not there. Go to YouTube and then type in AOA USA. And all of our live streams will come up, and it's one that we just did, so you could check that out. Anyway, there's so much that's going on. For Northern California, Thursday we're going to have a legislative update, and they'll go over California as well, but then specifically address Oakland, San Francisco, Alameda County. And so that's more specific for our Northern California audience. And this is for our Southern California audience today. And next week, besides that one with the legislative update by Richard Beckman at 11, at 10 o'clock, we have a certain president of the AOA that will be sharing with you how you can attract 67% more potential tenants for free. And there's definitely no strings attached to that. It's a simple thing that you can do, and so I will be sharing that with you. It'll be great. So what we want you to do, we definitely want you to subscribe to the AOA newsletter, and you can do that whether you're a member or not. If you're not getting it, check your spam or sign up, and you can do that by going to aoausa.com. And at the very bottom of any page, basically, there's a place where you can subscribe. And just, you put in your name, your email address, and your zip code, and then we'll send you things appropriately. And so anyway, so that's where we're at. Also, I know some of you are going to be already asking questions. Try to hold the questions, but if you just can't help yourself, please remember to put the location and just some of the important things that we would need to know whether you're under rent control or not, and everything. So location, maybe how many units it is, and that'll help us answer your question. So right, so our today's speaker, he's the founder of Brennan Law Firm. He's heavily invested into our industry, and he's been such a friend to AOA. He's a favorite, one of the favorites for sure at the AOA trade show. And the AOA trade show is happening, and it will be October 27th at the Long Beach Convention Center. So we're excited about that. In May, we have an in-person seminar in San Diego. In June, we'll be having one in Oakland. And so we're starting to get back into real life and real in-person stuff. So that'll be great. And he's a landlord himself, and he is an expert in this field. He's been doing it for years. It's my pleasure to introduce to you today, Michael Brennan.
Good morning, Jeff. How are you?
Good.
Nice to be here. So before we get started, let me just say a few words about what we're going to talk about today. Obviously, we're talking about AB 2179. As Jeff brought up, it really boils down to interpretations and how you interpret the laws that come out. So in light, he brought up there's different opinions, how the laws are applied, what you can do, what you can't do. I will agree with that, and I will add to that today's presentation is not legal advice. It's my disclaimer. I'm giving you my interpretation of 2 years worth of laws spread out and now compacted into one. Because of our location, my office is in Arcadia, California, which is Southern California. We deal primarily with Southern California. The impact of 2179 really hits hard in LA County, so a lot of what we're talking about today will really be geared towards LA County and LA City. I will address the surrounding areas as well because they're great examples of where it does hurt a landlord versus where it doesn't hurt a landlord. So that's my disclaimer. It's not legal advice, it's my interpretation of the laws. Okay, so let's just jump right in. AB 2179 was passed on March 31st. It was passed as emergency legislation, which means it went into effect right away. We'll talk about what it is. We'll talk about what it isn't. We'll talk about how it hurts landlords. We'll talk about a specific subset of landlords that it actually helps out quite a bit. And we'll talk about how that will apply to various situations. And I will be addressing the questions that show up as well. As Jeff said, if you could, throwing in your city would be very helpful for me. And I will say, after doing this for 2 years and having all the laws change, some of them change every single month, I'm saturated and I can't remember every moratorium's details perfectly, but I will do the best I can. If I say something that either contradicts something else I said or seems to contradict it or doesn't address a question that's answered, be patient, but please call my office. I'm happy to talk it out with people. And you can ask my staff a lot of the questions you want to ask me if you can't get in touch with me. They're very well trained. They go through these processes as well. I talk to them about the laws. I send around little flow charts so they know what's going on. So the staff knows what they're talking about. Ask them the question as well. All right, so AB 2179, what is it? It is essentially an extension of several other laws that came before it. Back in March of 2020, we got hit with the pandemic. Every single city and municipality created their own moratoriums to protect the tenants that were thought to be affected by COVID. And then the state came out with a law called AB 3088. That was then followed by SB 91, and then SB 91 was followed by AB 832, and now we have AB 2179. When I talk about any of those three preceding laws, 3088, SB 91, or AB 832, I'm going to lump them all under AB 832. And the reason I do that is just to keep things simple, but also SB 2179 is an extension of AB 832. So that's what it is. It doesn't extend the entire law. It's got limitations on it. And those limitations are good for many landlords. The extension does hurt quite a few landlords, and we'll talk about that. We'll get into details in a little bit. Let's talk about what SB 2179 is not. It is not a blanket extension. It is not protections for tenants that any old tenant that just doesn't want to pay their rent. It is not a protection for tenants who were gaming the system and refused to apply to Housing is Key for the rental assistance funds. The way AB 2179 works is it took what was already in law, AB 832, let me back up. AB 832 was set to expire as of March 31st. What AB 832 did was it set out some protections for both landlords and tenants. It required the landlords to fill out an application with Housing is Key if they were attempting to evict a tenant for non-payment of rent. And as many of you already know, there's three distinct time periods under the COVID moratoriums. There's what we call the protected period, which was March of 2020 through August of 2020. Then there's the transition period, which essentially happens October 1st. I think it's either September 1st or October 1st. I believe it's September 1st of 2020. Let's just call it two time periods, protected period and transition period. And transition period is September 1st, 2020 through, let's call it October 1st, 2021. Then there's the recovery period, which is a different period. All of those laws, depending on which period of time you were trying to seek rent for. So if it was in that protected period versus if it was in that transition period versus if it was after that transition period, October 1st, 2021. Those laws all set out specific requirements that had to be met in the notices for non-payment of rent. In addition to that, those laws all had what's called a preemption provision in them. The preemption provision is somewhat key today. The preemption provision really dealt with two components of the local moratoriums. It dealt with the moratorium themselves and the ability of a municipality to extend their moratorium, create a new moratorium, modify their moratorium. And the preemption clause also dealt with the period of time that the tenant would have to pay back the money that they owed. What do I mean when I'm talking about preemption? When the state creates a law and says it preempts local laws, any contradiction between the laws would be resolved by applying the state's law. So you're always, in a preemption situation, you're always going to apply the state law. It got a little strange because, for example, LA County only decided to acknowledge the preemption when it came to non-payment of rent. So, like I said, it preempted the local moratoriums, and I'm going to come back to LA County in a second. It prevented them from extending, modifying, creating new moratoriums, and it talked about the repayment plan. When it came to extending or creating new moratoriums, the state laws said that whatever a local municipality had on record as of August 19th, 2020, that's what they're stuck with. They can't create new ones, they can't modify theirs, they can't alter them in any ways, and they can't extend them. And so most municipalities understood what that meant. Los Angeles County, on the other hand, again, it comes back to interpretation. Los Angeles County took a unique position that said, well, we think that the preemption only applies to non-payment of rent cases. And so we will acknowledge that non-payment of rent cases are controlled by the state, but we will not acknowledge that the state's COVID moratorium controls all of our other tenant protections. Myself and any other attorney that has looked at this disagrees and believes that position is completely illegal. But having said that, there's a lot of risk if we were wrong. It's a $5,000 a day penalty in the County of Los Angeles. It's a really onerous position to be in as a landlord. Do I risk $5,000 a day and move forward with my evictions? Or do I take what the county's giving me? And as you might imagine, most landlords say, I'm going to take what the county says, because it does acknowledge that the state controls when it comes to non-payment of rent. Okay. The city of LA had a different moratorium. They had different language in their moratorium, and they didn't really have to worry about that. The city of LA's moratorium was what I would call more stringent. It said that landlords were not allowed to endeavor to evict, which included even serving a notice. And it said that the local moratorium would not expire until the city expires or rescinds their state of emergency. So the city of LA has not really had to change their moratorium. It was well suited to what they were trying to accomplish. They haven't had to change their moratorium since August of 2020. The county, on the other hand, I already explained their position. They think they can change their moratorium anytime they want. And so almost every single month, they have created a new moratorium, extended their moratorium, all in violation of the state laws. Okay. Now, let's talk about 2179. As I said, those notices had certain requirements. They had to have certain language in them. And the whole point was to protect both landlords and tenants. Those three laws, summarized in today's webinar as AB 832, the protections that they laid out for landlords were, we're going to allow the landlord to terminate a tenancy for non-payment of rent if they follow certain requirements. For example, using these specific notices that tell the tenants their rights. Additionally, if the tenant didn't fulfill its obligations under AB 832, for example, filling out a declaration and returning it within a certain amount of time, typically 15 days under the notice, then the landlord was permitted to move forward with the eviction. When the landlord files the eviction under these laws, the court cannot issue a summons, which is basically the court telling the defendant, hey, somebody has sued you, you have to come to court and file an answer, or some sort of pleading. The court was not permitted to issue a summons unless the plaintiff or the landlord filled out a declaration and signed that declaration under penalty of perjury. And there were a lot of questions in the declaration. Most of them had to deal with whether the landlord had applied for housing as key and whether the landlord had received any rental assistance funds. So, like any landlord would, they filled out the declarations and they submitted them. Now, again, we're talking about tenants who did not return their declarations. If the tenant returned the declaration, then there were other requirements. The tenant was supposed to pay the landlord 25% before October 1st, and if they did that, the rest of the unpaid rent would become consumer debt that the landlord would have to go after later. If they did not pay the 25% of what they owed for that transition period, then again, the landlord was allowed to file the unlawful detainer, and the landlord would fill out that declaration again. So let's move into now the situations where the cases have been filed. Where the cases have, well, let me go back to 2179 and what it did. As I said, all of these laws were set to expire March 31st. Coincidentally, or not coincidentally rather, the funds for housing is key and the ability for a tenant and a landlord to apply for those rental assistance funds also expired on March 31st. Now, the fund itself had $5.2 billion in it. And recently, and we all know when every time these laws were extended, landlords got very upset because they were losing money. They had no remedy for their losses. And so when AB 832 was signed into law, everybody will remember Governor Newsom said, oh, this is it. No more extensions. We're not doing anything more. We've come to the end of the line on this. Well, what happened was through, I don't know if it was incompetence or mismanagement of the training and how they were dispersing these funds. The state has only gone through, my last understanding was about half of the $5.2 billion has been sent out to landlords. Initially, landlords were receiving the funds very quickly. That started to slow right away. Now, if you believe the tenants' rights groups, and I have no reason not to when they're talking about these numbers, Housing is Key is reporting that there's 150,000 applications that have been turned in that have not been assessed. In other words, they haven't been denied and they haven't been approved. They're just in limbo. In fact, most of them haven't even been assigned to a caseworker. So every single day I deal with clients who call me and say, Mike, I turned this in months ago. I keep checking the website. There's no status. There's no caseworker involved. I did receive my email that says I applied, but there's no status whatsoever. And that's where the problem comes in, and that's why we have 2179. The tenants' rights organizations went to Sacramento and they said, look, we know that you said no extensions, but there's a lot of innocent, impacted tenants who are about to be evicted if you let this expire because their applications are in limbo. And that is true. Their applications are in limbo. So the state did this emergency legislation through AB 2179, and they said, okay, we're going to extend the protections through June 30th, 2022. Now, what did they extend? This is where there's some confusion. They did not extend every single protection that AB 832 had. They did keep the procedural process in place, and we'll talk about that in a second. But they extended the protections only to those tenants who had applied to Housing is Key on or before March 31st, 2022. So again, you've got a lot of tenants out there who had not applied for Housing is Key, and they refused to apply for Housing is Key. Some of them just didn't know, I guess, that they needed to apply for Housing is Key. Whatever the case may be, as of April 1st, any tenant who had not applied for Housing is Key is no longer protected under AB 832 or any of the preceding laws, nor are they protected under AB 2179. Those protections are now gone. Okay, so what does that mean, practically speaking, for landlords? The answer is it will depend on what jurisdiction you're in. Do you have a local moratorium? If you do not have a local moratorium, there will be certain procedures you should follow. If you have a local moratorium, you're going to have to interlace the local moratorium with the state's moratorium. You're going to have to figure out what your municipality decided as far as the preemption is concerned. So again, I'm going to go back to the city of LA and the county of LA and use them as my two primary examples. In the city of LA, if your tenant has not applied for housing is key, again, that their ability to do so has ended. March 31st, it was over. So what do you do where April 1st rolls around? Well, under state law, what you could do is we are now back to, essentially, we're back to pre-COVID evictions. So forget LA City and LA County for a second. Let's just talk about a jurisdiction that has no moratorium in place. For example, Orange County has no moratorium in place. What do you do in Orange County if your tenant never applied for the rental assistance funds? Let's assume for a second you have unpaid rent from the COVID period, March 2020 through March 31st, 2022. That's one component. But let's also assume that your tenant doesn't realize what's going on and they failed to pay rent for April 1st, 2022. You've got two different scenarios you have to deal with. With regard to the non-payment of rent for the COVID period, you still have to follow all those prior laws. You still have to serve the required notices with the required language. But for April 1st, there's a new notice. It's back to a 3-day. It does have some required language in it, so make sure you're using a proper 3-day. But you've got these two different time periods. For the April 1st and onward, there are no protections anymore. That's the kind of eviction that will move through the courts rather quickly compared to the COVID rent eviction. Why is that? Under the COVID rent evictions, the laws, even though they gave all these procedural requirements with language and notices and declarations the landlord had to sign and declarations the tenant had to return, they even protected the tenant when they were in court. So there's two particular protections. All those old laws, I call them old, but they're not old, but I'll call them pre-April 1st. All of those laws that protected tenants during COVID say, if the tenant fails to file the declaration after they've received a notice to pay rent or quit, and the landlord moves ahead with an eviction, the tenant can still go into court and file that declaration. And if that happens, the court gets to decide if their failure to file the declaration was a mistake or due to excusable neglect, or I think it's mistake, surprise, excusable neglect. So if the court figures out, or determines rather, that the reason the tenant never filed that declaration, the court can, and we've had plenty of judges do this, they can order the tenant to pay the 25% now within 5 days. And if the tenant does that, the court will hold the case, or they have the right to dismiss the case, actually. So that's all these COVID laws. So the tenants are still protected in those procedural components, even under Tenant 2179. April 1st rent, though, there's no protection. So you have some options. If you have already served your notice, you can decide, and you have not moved forward with an eviction, and the tenant has failed to pay rent for April 1st. If you serve that new April 1st notice, you're going to knock out all your old notices. But that may be worth it. The reason I say that is because you can still go after all of those notices in small claims court. That's what all of those laws said. Was the whole purpose of those laws was the legislators actually came out and said, we want unpaid COVID rent dealt with through small claims court. So you can still do that. And it might be wise, you have to make the decision for yourself given your particular situation, but it might be wise to go through the COVID debt through small claims court. I think it would be a lot easier than trying to evict them for that COVID debt because there's procedural protections that remain in place. Just go after the April rent. Serve the 3-day pay or quit just for April rent. You're going to knock out all your old notices. File your eviction based on April's rent only, and file your small claims action for the non-payment of rent, and reserve your right to go after that. You'll be able to serve them in court if they answer the eviction because you'll know where they are, you'll know where they're going to be. So that's one option. The other option is if you haven't served any notices at all, but they owe you for COVID rent and April's rent, you can serve all of your notices at one time and wait the amount of time, the legally required amount of time, and file your summons and complaint based on all of your notices. Now again, for the COVID rent, you're still going to have to sign those declarations that say, did you file housing is key? Were you denied? Have you received any rental assistance funds? So as long as you answer that honestly, your case should move forward, assuming that you haven't received any money and the tenant hasn't been, or has been denied, or nobody's notified you that the tenant has applied to housing is key. And you can go to court and let the court hammer out which notices will work and which notices won't work. Even if the court were to say, oh, well, you messed up procedurally here, so I'm going to knock out all your COVID notices, you would still have your 3-day pay or quit from April 1st onward. And so your case would still be able to proceed. So that's another approach. Now, that's the state law without looking into any sort of moratorium, and that would be a situation in Orange County. Let's now delve into LA County, and by LA County I mean all the cities in LA County, including the city of LA. You have different situations, and your outcome will depend on which situation you're forced to follow. Let's talk about the city of LA first. They had a very stringent moratorium, as I said before. It actually prohibits the landlords from even serving notices where the landlord has a reason to believe that the tenant would be protected from eviction because they were negatively impacted by COVID. All right. So if that were the case and your tenant failed to file the housing is key application, are you able to move forward with an eviction right now if your property is located in the city of LA? The answer is it depends. If you believe that your tenant was really impacted, or you have no reason to believe they weren't impacted, let's say it that way, and they didn't apply for housing is key, but you believe they are protected by that moratorium, then no, you're not allowed to even serve a notice still. You won't be able to serve a notice until the expiration of the state of emergency. And at that point, you won't even be able to serve a notice in the city of LA for a period, for the COVID rent, for a period of, I believe it's 12 months after the expiration of the state of emergency. So for that, you're really hamstrung in the city of LA. So you won't be able to move forward on that. But the city of LA's moratorium has a couple of other provisions that might allow you to move forward where your tenant did not file their application. So for example, they've got a provision in there that says that the landlord is not violating the city's moratorium where the landlord does not have a good faith belief that the tenant, I apologize, the way they said it is very strange. They actually inverted it, so I'm going to put it in English. If the landlord has a good faith belief that the tenant is not entitled to the protections of the moratorium, then the landlord is not violating the moratorium and they could move forward. Let me give you a real life example of this. We had a case where the tenant was not paying rent and they notified the landlord that they were impacted by COVID, but they kept posting on their Facebook page how great everything was for them, how their business was doing fantastic, and then they were going on vacation, and funny enough, they actually went on vacation in Florida and ended up sitting 20 yards away from the landlord, who saw them on the beach and approached them and said, "What are you doing?" etc. In that situation, I think it's a reasonable assumption that the tenant was scamming the system. And if the tenant is scamming the system and is not really impacted by COVID, then they're not entitled to the city's moratorium protections, and a landlord would have the right to move forward with an eviction under that. On top of that, LA City's moratorium also says that, I'm paraphrasing again, but it says that landlords are not violating the city's moratorium until the tenant puts it in writing to the landlord that they're violating the moratorium, for example, by serving a notice or filing an eviction. And the tenant gives the landlord 15 days to rescind that notice or the eviction, and then the landlord fails to do it within 15 days. In other words, there's a safe harbor in the city of LA's moratorium. There's a safe harbor for landlords where even if they were to file the eviction, they have a safe harbor of 15 days from the date that the tenant notifies them in writing that they're violating the moratorium to rescind that moratorium. And if the tenant never notifies them in writing, then they're not even, the landlord is not violating the moratorium. So if those two things were the case, your tenant is on Facebook announcing how great their life is, you're running into them on vacation in some other state, yet they're trying to claim that they've been impacted by COVID, the reasonable belief arises that it's a scam, they're not protected by COVID, and the landlord would have a reasonable belief that they're not protected by the moratorium and they could move forward. And additionally, if the tenant never notifies them that they are violating the moratorium, then they, again, could continue moving forward. So if that's the case, your tenant never filed for housing as key, you filed your eviction because you have reason to believe that the tenant is scamming the system. I'll give you another reason to believe the tenant was scamming the system. I had multiple clients call me and say, look, we've applied for housing as key, and we've asked this tenant over and over and over to apply. The tenant has told us they absolutely refuse to apply for housing as key. That's another good indication that the tenant is scamming the system. They don't want to apply for housing as key because they know they'll be denied because they can't produce the evidence that they were negatively impacted. So in those situations where the tenant refused to apply for housing as key, you're in the city of LA, would you be able to move forward with an eviction? In those situations, I would say yes. You can move forward with your unlawful detainer based on that. Again, you're going to have to fill out the declarations for all that, and you're going to have to answer those declarations under penalty of perjury. That's another way of saying you have to answer the declaration honestly. But that's a situation in the city of LA, and it's a unique, narrow situation. You've got reason to believe they were scamming the system, they refused to apply for housing as key, and they haven't notified you that you're violating the moratorium. Yes, move forward. Okay, what about where they applied for housing as key and they're in limbo right now? City of LA, I would not move forward with that eviction unless you have really, really solid evidence that you could bring to court that shows that they were scamming the system, they were never impacted at all. For example, a tenant takes possession of the property, moves in, everything's great, and then they ask you to put new carpet in. You say, no, I'm not going to put new carpet in. And they send you a text saying, hey, I'm not going to pay my rent because you won't put new carpet in. Well, you've got pretty strong evidence there, and they've been paying their rent the whole time. You've got pretty strong evidence there that they're not impacted by COVID. They're not withholding their rent for COVID. And they're scamming the system at that point. They're just not paying rent because they want new carpet. And let's say they have applied for housing as key and you're in limbo. Even that situation, if you've got the proof, evidence that they're scamming that system, I would say that it's more risky at that point, but I've had plenty of clients tell me, Mike, let's move forward and we'll take our risk. Until they notify us that we're violating the moratorium, we're not violating the moratorium, so let's move forward. Now let's take a very common situation. Tenants applied for housing as key. You have no reason to believe, or you have no evidence, let's put it that way, that they're scamming the system, and you have no way to prove that they really weren't impacted by COVID, and their application is simply sitting in housing as key right now. Can you move forward with an eviction? The answer is no, because you have to go back to the moratorium, which says, if you have a good faith belief that they're protected, you have to follow the moratorium. The moratorium says you cannot endeavor to evict, which includes serving a notice. So you're stuck. And that's the city of LA. And that situation is very common. And so in Orange County, for example, where they don't have a moratorium, and then the city of LA, where they do have a moratorium that continues to protect tenants, you can't even serve notices. In those two situations, AB 2179 is a nightmare for landlords because it extended those protections, and they're protected in LA City's case, they're protected under the moratorium. And so it's just one more extension of the protections. And in those situations, the protections, the extension through 2179 is terrible for landlords. But let's take LA County. LA County, the extension of 2179 is a godsend to landlords who have properties outside of the city of LA, outside of Pasadena, and I'm not sure whether Beverly Hills allowed their moratorium to be rescinded yet or not. I know they were talking about it. But Beverly Hills, Santa Monica, Pasadena, city of LA, there were a handful of cities in the county who had those very stringent moratoriums that prevented landlords from serving notices, maybe 5 or 6 cities. Outside of that, the LA County took the position that their moratorium controls every city in the county, unless the city had a more stringent moratorium, like the city of LA could be argued to be more stringent. Pasadena's could be argued to be more stringent. So with the exception of those handful of cities, the county takes the position that their moratorium controls. Okay, let's go with that. The extension of 2179 actually helps them because right before 2179, many of you already know this and you'll remember this, on January 26th, the county passed a resolution which was an extension of their moratorium. And it said, we're going to phase this out over 3 periods. And if you looked at it carefully, those 3 periods actually went through June 30th of 2023. So we're talking, at that time, it was another 18 months extension. And it did protect those tenants. Again, it went backwards. It actually, when AB 832 and its preceding laws came out, and the county acknowledged that they preempted the county's moratorium, it opened up the ability for landlords to serve non-payment of rent notices in the county of Los Angeles. So actually, it kind of, those laws covered under the umbrella AB 832, they kind of curtailed the county of LA's ability to protect tenants. That's good for landlords. January 26th, the county came out and said, hey, here's our new resolution. By the way, we're taking a step backwards. Now that that's going to expire on March 31st, AB 832 will expire. As of April 1st, we're going back to protecting all tenants from non-payment of rent evictions. You're not going to be allowed. Now there's some requirements. The tenants have to notify the landlord within 7 days of rent becoming due that they've been impacted. But the county's moratorium has a self-declaration component that said, if they did notify you, that's enough. They're protected now. So the county took a step backward, made their moratorium more stringent as of April 1st. And in that situation, the extension of AB 832 under 2179 works to the advantage of a landlord. Why? Because the county's already acknowledged the state law preempts them in the area of non-payment of rent. So as of April 1st, when SB 2179 went into effect, it basically puts the county's moratorium, at least the non-payment of rent component, on hold until July 1st again. The county can't do anything. Now, Jeff asked me a couple days ago, well, the county's been, flouting the law for almost 2 years now. What's to say they won't here? And the answer is nothing's to say they won't, but because they've already acknowledged that the state laws do preempt them in non-payment of rent, I would be surprised if they came out now and tried to take the position that that 2179 does not also preempt them in the area of non-payment of rent. So let's just assume that the county acknowledges that 2179 controls them, and 2179 basically pushes out the county's resolution for non-payment of rent to July 1st, 2022. All right. So again, now you can still, for 90 days, landlords in the Los Angeles County can continue to serve non-payment of rent notices. And again, I want to remind everybody, and this question actually came up, there's two different time periods we're talking about, or two different definitions of rent. There's COVID rent, which I will call all the rent that came due between March of 2020 and March 31st, 2022. Let's call that COVID rent. And then there's, non-COVID rent, which starts April 1st. So for the next 90 days in LA County, a landlord, even if the tenant hasn't paid rent, COVID rent, the landlord, again, gets to decide, as of April 1st, what do I do? Well, I would counsel a client who called me with that dilemma and say, look, put the COVID rent on the back burner for right now. Don't move ahead with that because there's too many procedural hoops you're going to have to jump through, and there's too many tenant protections built into that. Instead, simply file your 3-day non-payment of rent for April's rent and move forward like a pre-COVID eviction where they don't have all these tenant protections. And that will move through the court a lot smoother than any eviction seeking COVID rent. So that's two examples. Most jurisdictions are going to fall into the category of 2179 hurts me because it extends those provisions. Some jurisdictions like LA County are going to fall into the category that 2179 actually helps me because without it, I'm limited in what I can do, whereas 2179 kind of opens it up to what I can do. So now there's a few other components to talk about with 2179 that are misunderstood. Again, it does not protect every single tenant out there. It does not protect tenants that failed to file their application before March 31st, 2022. It does not protect tenants that filed their application but were denied assistance. So those are two very important categories where 2179 is not protecting the tenants. It is limited, and the legislators came out and said this. The whole purpose of extending it was, well, the whole rationale for extending it was we have what the state is saying, at least 150,000 applications that have not yet been processed, not yet had a caseworker assigned, and they didn't want to evict people who would otherwise receive those benefits. They also spin the situation to say, we also want to protect landlords, and a lot of those landlords will, once those tenants are approved, will receive those rental assistance funds. So that's how 2179 will protect the landlords as well. And theoretically, that's true. The question is, yeah, but when am I going to get the funds? I have several clients that are telling me, Mike, I applied months ago. I mean, remember, this program's been in effect for what, a year now? I applied months ago and I still haven't received a check. And yes, that's absolutely true. And that's why we have a backlog of 150,000 applications. So yes, it's true that it does give limited protection to landlords. They may still receive those funds, but it really hamstrings those landlords in those jurisdictions where they could otherwise move forward if AB 832 had just been allowed to expire. So that's kind of 2179 in a nutshell. It is not a complete protection for any tenant out there. It is only protecting those tenants that applied to Housing is Key prior to March 31st. It is extending those protections to those individuals, and it is extending the procedural hurdles that landlords have to jump through in order to file and prosecute these evictions. But as of April 1st, it's a whole new ballgame. If your property is located in a jurisdiction that has no moratorium, it's like pre-COVID evictions. You can move forward based on a 3-day notice again. If your property is located anywhere in LA, like I said, you've got to jump through the hoops of figuring out which moratorium controls and what does it really say. And again, I'll go back to, and I've said this many times since COVID took effect, or when COVID arrived, this is not the time for a do-it-yourself approach. Even if you read the moratoriums, you can read that moratorium 20 times. If you're not a landlord-tenant attorney who understands the laws, is used to reading the moratoriums, knows how this stuff is going to play out in court, you may be shooting yourself in the foot by attempting to develop some sort of an opinion on what the moratorium means. There are plenty of hidden gems, I'll call them, in these moratoriums that allow landlords to move forward that landlords wouldn't otherwise know. I'll give you another example based on nuisance cases. It's a misbelief that you're not allowed to do nuisance evictions in LA County and LA City because of the way their moratoriums are written. And I disagree with that completely. Yes, it does limit some nuisance evictions, but it does not by any stretch prohibit all nuisance evictions. You just have to read the subtleties in these moratoriums. And if you're not a landlord-tenant attorney, like I said, don't try to do this yourself. Call a landlord-tenant attorney. Call our office. If you're not using us, we would like you to give us a try, but if you don't, that's fine. Use another attorney to help you work through this and figure out what protections you really have now and what your best approach is for both the COVID rent and the April 1st moving forward rent. There are strategies you can employ to navigate through this system. Most cases, or maybe a majority of the cases, there are strategies you can employ to navigate through the system. Finally, I will say that, we heard it with AB 832, no more extensions, no more extensions. And we're hearing it again with 2179. No, this is it. We're going to take these 90 days and work through these applications and get this thing back on track. I would suggest to landlords that they should take that with a grain of salt. We've heard that time and time again. In light of several of the moratoriums I've seen, in light of LA County's attempt to extend their moratorium through June of 2023, there are a lot of people who have an interest in continuing this situation as long as they possibly can. And I find it hard to believe that the state is going to, after they've mismanaged Housing is Key this badly, through now, when it's been in place for a year, I find it hard to believe that they're going to get all these applications reviewed, assign a caseworker, and get these checks out in 90 days. I just don't see that happening. So one of two things is going to happen. Either they're going to continue to allow it to expire, and if they do that, municipalities like LA County, they're probably going to revise their moratorium again. And I wouldn't be surprised if the county says, well, we're going to take what we had in place as of April 1st, and even though it gets pushed to July 1st, we're just going to start over, phase out, or a 3-tiered phase out, and go back to the protections. So that's one thing. Or they're going to come out and say, hey, look, the tenants' rights have all reached out to us, and we still haven't been able to get all these applications approved, and we still haven't been able to get the checks out. So we're going to extend this another 90 days to possibly even to the end of the year, and let this thing work itself through. So I guess in the end, what you have to decide is, what jurisdiction are you in? What is your attorney telling you your options are? And whether you believe that this thing is going to work itself out in the next 90 days. I don't believe so. So stay tuned. Hopefully it is. Once before I said, I think we're starting to see the light at the end of the tunnel, and many municipalities surprised me and went backwards. So I won't say that. Hopefully we are. But I do think that you should just stay tuned. If you're in one of these jurisdictions like LA County, there's a lot of cities in LA County that are going to benefit from 2179. Work yourself through it. Stay calm, cool, and collected, and contact an attorney to figure out what your strategies are.
All right. Well, thank you so much.
You're
Mike.
very welcome.
Yeah, thank you so much. And related, but have you signed the Howard Jarvis petition that they have out to repeal the death tax?
I have not signed that. To be honest with you, I knew that they were talking about the petition, but I haven't seen the petition. So if you could forward me a link or something, I'd be happy to. All right.
So if you're in any part of California, all of the AOA offices have the petition. Please go in and sign. They're trying to get that done by April 8th, and they still need a lot of signatures. And also, the AOA branches are drop-off points if you do have the petitions. Please get on the Howard Jarvis Taxpayers Association website and take a look at what's going on there. And definitely let's repeal the death tax. That was a real bad one, Prop 19, and so we need to repeal that. So that's one thing. And number two, you just mentioned it, but you said that the county might go back to what they were trying to do in June. And so the question I had, well, we have this lawsuit against LA County. Should we drop it or not? And you said no, because...
Exactly, yeah. Right. So there is for those of you who don't know, there's at least 10 lawsuits out there right now suing various municipalities, and the city and the county of Los Angeles both have multiple lawsuits suing them. There's a lawsuit in place right now against the county of LA. When they passed that resolution on January 26th, extending their moratorium, AOA was part of it. There's a couple groups that got together and filed a lawsuit immediately to put an end to it before it went into effect on April 1st. And Jeff and I were talking about this the other day as well. Does it make sense now that we've got SB 2179? Should we just walk away from the lawsuit? Absolutely not. Like you said, the minute July 1st hits, you can count on the County of Los Angeles moving forward with that resolution. And so I think, if anything, we were hoping to have an emergency hearing on that lawsuit and have it go into effect before April 1st. To the best of my knowledge, that didn't happen. So the 90-day window that we've got right now, in my opinion, actually works to our advantage, because it's going to give us time to just tighten up our pleadings, get everything in line, and get it filed, and hopefully get that case further down the line before July 1st, when the county's it's going to be fair game for the county to reinstitute their most recent iteration of their moratorium. So right. I wouldn't walk away from that lawsuit at all.
Yeah, so we're not planning on walking away from it, and we're in that one. And also, if you haven't donated to the Political Action Fund, we definitely could use your support in that, because there is a lot of work being done by the attorneys, and those attorneys aren't making $50 an hour, if you know what I mean. So you go to aoausa.com/PAC, that's for Political Action Committee, and you can donate there, you can call in, you can mail in a check. Anyway, that would be great, would be super helpful. And the other, this is just off topic, but it's places where I think we need to be really politically active and just aware of what's happening. So I want to bring attention to it. It's the LA City tenant screening ban, banning the criminal, banning the eviction, banning the credit criteria history, where they're just wanting to blindfold housing providers. How much potential do you think that has, and do you think we should be writing our city council members?
I think you absolutely should be not just writing your city council members, but if you can attend the city council meetings, you should be there. People should be speaking about this. Jeff, you're absolutely right. The city is attempting, it's worse than you know. There's some bills up in Sacramento that are far worse than that. But the city is attempting to essentially prevent landlords from screening applicants. And as I said, it actually gets worse. There's some legislation up in Sacramento. It didn't, to the best of my knowledge, I think it got knocked out this session, but I believe it will be back. What it says is not only, when you couple all the legislation together, the picture that is being painted is not only will landlords not be able to screen tenants and not be able to use traditional criteria that we've used for years and years and years to determine who's a better risk than versus who's a bad risk, but there's going to be, or at least the movement was, for preferences in tenants. So not only will you not be able to screen, but if you had two applicants and one was a local applicant who was low income versus another applicant who maybe is not local and is not low income, you would have to give preference to the low income local tenant before you accepted the non-local, non-low income tenant. I don't have to explain how that could cause major problems, especially if you're not allowed to do tenant screening, such as not allowed to pull a credit app, you're not allowed to do a criminal background. I mean, it really is mind-boggling to me that the state and the city and the municipalities are working in conjunction together to force landlords to accept basically whoever walks through the door into their buildings. And simultaneously, and we should actually go into this a little bit about LA County's moratorium, simultaneously preventing landlords from evicting tenants who cause problems, who are not paying their rent. Let me just go off on a little bit of a tangent here about one more thing about the LA County's most recent iteration of their moratorium. If you read between the lines, or if you read as much legislation as I do, and you read the cases and you see what the cities are doing, and you see what the counties are doing, and you see what the state of California is doing, the last page of LA County's most recent resolution or moratorium should alarm everybody. What it really said was, it's almost an admission by the county. The county knows that the COVID situation is more or less over. The worldwide, the economies have reopened. There's very few, if anybody, still being impacted by COVID. And yet they wanted to extend their moratorium for 18 months. And reading between the lines, the last page of their resolution really explains their rationale and their driving force. What it said was, the county has learned a lot of lessons about tenant protections during COVID, and they want to take this opportunity to beef up their tenant protections. And if you know the county's tenant protection ordinance, it's already pretty beefy. On top of that, they said plenty of cities in the county have come to the county and asked them how they can create their own tenant protection ordinances, and the city essentially, I'm paraphrasing it, but they, on that last page of their moratorium, they said, we're going to extend this and take that 18 months to beef up our own tenant protections under our just cause eviction ordinance, and we're going to help the other cities in the county create their own just cause ordinances. So if you put the bigger picture together, you've got a bunch of cities creating just cause ordinances, the county's beefing up their just cause, the city of LA and the state of California are trying to limit your ability to screen tenants. In other words, they're trying to expand the door to every tenant. They're trying to force you to accept anybody that walks through the door, while simultaneously cutting off your legs and your ability to get rid of problematic tenants. What is the policy? What is the bigger picture here that us landlords are missing? What is the end game here? Just have a tremendous number of buildings where They're a nightmare to live in. All the good tenants move because, these buildings are just becoming horrific places to live and raise a family. What is going on? It's very difficult to explain what's going on. I can't even begin to get into the mind of these people. It's as if not a single one of them has ever lived in an apartment or owned a rental property, and it's all just a utopia they're trying to create, not recognizing human nature, not recognizing the ability to maintain an asset or maintain a building in light of all these things. It's absolute insanity. And short of a miracle, Jeff, I don't see this changing anytime soon. The governor's come right out and said, hey, California is the beacon for the rest of the country. And I'm literally starting to see it in other places as well, these growing movements. It's a very difficult time in California to be a landlord.
Right. So really we're asking you to become politically active and talk to your city council members, call, email, send them real letters, and that's not all that we can do. We have lawsuits, and then there's all kinds of other things that we can do, and things that we're trying to we are exploring, because we have to fight in every way that we can, nonviolent, right? So
I'm glad you qualified that.
Right, got to qualify it, because I know some of you out there are ready to, punch someone out, and we do have to exercise restraint, but. In the bottom of this YouTube, if you're watching it on YouTube or after the fact, you'll see that there's a link to a letter that I've written to the LA City Council members, and really it's kind of it's written generically. Maybe that's the one that's generic. There's two different ones I did, one for the state, one for LA City Council, and anyway, I want you to use that. You can use the talking points, or you can just plagiarize completely. It's there because I know that you're busy, and you'll agree with just about anything that's there. But the way that we're trying to phrase these things is how it's even bad for tenants, how it's bad for the community. So you'll pick up on that as you read it, and definitely please share that. And if you like this video, if you think that there's something worth sharing with your other housing provider friends, and I know that there is, please share it with your friends, because everyone needs to know what's happening, needs to stay in the know. And right now we're gonna get into questions. Again, give the city how many units you have, and just some vital information for us to be able to answer the questions. But before we do that, we have a sponsor. It's Livable, and we're gonna, guys, go ahead and run the message that's from them.
Hello there, AOA members. This is Daniel Sharabi, CEO of Livable. We've been partnered with AOA now for some years to bring our ratio utility billing services to membership. And what really sets us apart, aside from quality service and taking great care of your residents and billing them back fairly and accurately for their fair share of utilities, is that we have no minimums. So that means if you've got a duplex or a single family home with an ADU, we're happy to help facilitate the utility bill back on your behalf. So we would love for you to get in touch and join all of these happy customers in using our service and celebrating conservation, but also increasing your net operating income. Livable.com/AOA is where you can find more information and ways to get in touch with us. We look forward to getting some time scheduled and to telling you more about the program and how you can do your part to promote conservation. All the best, and enjoy the live stream.
All right, thank you so much. And so now we're finally to it. We're finally get to these questions. Thank you for your patience. And yeah, I did forget. Hey guys, join AOA. We're one of the largest individually organized groups of apartment owners here in the state of California. And we're here to help you, to keep you in the know so that you're not making costly mistakes. We're also giving valuable information that'll help you get the best tenants, whether that's our tenant screening. We have the live stream that I'll be doing next week about how to attract 67% more applicants for free. And there's all these different, we got the magazine that's going out. You can call in. We have the free forms. You can call in and say, hey, how do I use this form? And if you're over your head, you call in and say, hey, how do I do this? We can kind of let you know these are the options that you have, or we'll send you to someone like Mike Brennan here, and he'll take care of you. And I know for if you're going to give him a call, maybe they get one question or about 15 minutes or something that they can.
Well,
How are you working it these days?
It depends on the situation. Like I said, my staff can answer many questions.
Right.
If my staff knows when they're stepping into an area they shouldn't, and they will put you in touch with either an associate or myself. Please be patient about the callbacks. It can sometimes take me a prolonged period of time to call people back. You can also go to the website and plug your question in the website. Same thing. Sometimes I can go a couple days without even seeing email because I'm busy focused on getting something done or filing something or drafting something or reading something that's important that's coming up. So just be patient. I know it's incredibly frustrating, but I also know that every landlord-tenant firm is facing the same challenges right now. Just like the landlords are all facing these challenges, so are we. So I'm happy to answer your questions. Sometimes, admittedly, they've come through AOA. They've said, hey, we can't get in touch with Mike. Here's our question. And Jeff has forwarded me the question, and I've either called or taken care of it. Yeah. But there's a lot of avenues to get in touch with me. That's both a blessing and a curse, because a lot of people use all the avenues to get in touch with me, and it really wraps up my time. But right. I love helping you. If I can get to it, the email or the phone call in. I'll talk to you.
Right, and so I just want to set expectations, whether it's Mike's office or another office. Everybody is inundated, and it is taking a few days to get back to people. So please just set your expectations appropriately. Right. We wish it were different than that, but it's just it's not a normal time right now. So anyway, we're going to get to questions. We have Shirley here in the city of LA. If a tenant is denied under housing is key, can they be evicted?
Short answer is yes. Yeah. So, but again, it's going to go back where it says City of Los Angeles here. So remember what I said. The city's moratorium prohibits even serving a notice. So they got denied under housing is key, right? You still got that moratorium to deal with. But if you have some reason to believe that they're scamming the system, and like I said before, refusing to apply to housing key would be an indication that they were scamming. But in this question, it specifically says they got denied. So I apologize. I think I actually said the short answer is yes. The short answer is no. You have to go through the moratorium. The moratorium prevents notices. Under certain circumstances, the answer would be yes.
Okay, great. Okay, on YouTube, Rich, if my tenant does not pay April, this month's rent, can include Jan, Feb, and March 2022 on my notice. Can I do that?
Not on the same notice. So this goes back to what I was saying before. The components of all those past laws, I'll call them all AB 832 right now, they specifically state that a certain notice needs to be used when you're seeking rent from a specific time period. So make sure you know which time period, all those, use the proper notices. And again, don't try to do it yourself. Just hire a law firm that knows what those notices are, and know you cannot do them all on the same notice. They all have different language.
Right, okay. All right, Dolores on YouTube. Resident has been denied rental assistance, but is paying his or her rent every month on time. Has not made an attempt to pay back rent. What notice can be served?
So there's too much information missing here. One, I don't know what jurisdiction Dolores is in, or her property. And two, I don't know what period of time she's talking about. Obviously, the tenant owes her rent. Right now, they're paying on time every month. This was one of the preemption issues in AB 832, is we're coming up on a period of time, depending on what jurisdiction she's in, that she may be able to file a small claims case for that unpaid COVID rent. So if that were available to her, I would tell her just go through small claims right now, file the case against her. She knows where her tenant is. It's easy to get the tenant served, and then she could possibly use that small claims case as leverage in a settlement to get that tenant to vacate and get her property back.
Great. Debbie on YouTube. Is California COVID relief paying for April through June 2020 rent?
No.
No. All
No.
right.
It expired March 31st, and that's what the original law said is we're going to pay through March 31st, and that's all they're doing.
Right. So, and that's why people have that recourse of filing an eviction.
Correct.
So there we go. All right. Jay Lim on YouTube. Do I need to pay relocation assistance if tenant voluntarily leaves apartment unit in city of Long Beach?
No.
No.
Every just cause eviction ordinance that requires relocation fees requires those fees when the landlord terminates the tenancy for just cause or a no fault, something along. I shouldn't have said just cause. When the landlord terminates the tenancies for a no fault eviction. When a tenant terminates their own tenancy, there are no relocation fees required.
Okay, I like this question from Larry on YouTube. LA County, City of Pomona, has the tenant self-certification issue become moot? New rules as a result of AB 2179 passing.
Right, so he's asking really about LA counties. Thank you for providing the city. But that's a perfect example of where 2179 is actually going to help this guy. Because without 2179, he's in Pomona. Pomona's moratorium expired, if they even had one. I don't recall Pomona having one, but if they did, they're under LA County. And LA County would have extended that for another 18 months. But because of 2179, he's got a 90-day window that he can serve a non-payment of rent.
Right, all right. Melinda, can I raise rent on my duplex in La Mesa?
La Mesa's LA County, and I believe it's LA County. I think so. Oh, San Diego County. I do not know what moratorium is in place for La Mesa. So I'm not comfortable answering the answer is I don't know.
Right.
You'd have to look at your
Yeah,
moratorium and see if it prohibits increases.
Yeah, and check, definitely the San Diego office you could call, the office that we have there, and also check the book. We have the website. The AOA magazine has a list of attorneys for San Diego. You can look at that. Then also on the website under contractors and vendors, you can see and give somebody a call for sure. City of LA, when can you serve notice for April or July rent if tenant has been denied rent relief?
So I love this question. This is a great question. City of LA, we were just talking about this, and here's a perfect example of knowing the nuances of that moratorium. City of LA has their moratorium, says you're not allowed to serve any notices until the expiration of the state of emergency. Now, you've got 2179 in effect. How does that impact? It doesn't really, right? So when can you serve for April? Well, AB 832 expired, or at least the rent relief component expired March 31st. The tenant's been denied. Why was the tenant denied? Right? So there's a couple reasons the tenant can be denied. They either didn't complete their application, or they were above the 80% AMI relief. So we don't know. But the reason I love the question is because if the landlord were to be able to figure out why the tenant was denied. So let's say that they were simply denied because they never completed their application. Then the question would become, well, was the tenant scamming the system? If the tenant was scamming the system, if you had any evidence that the tenant was scamming the system and really wasn't impacted, and let's face it, that could be why they were denied, is they weren't impacted by COVID. Then under LA's moratorium, you have a good faith belief that they were not entitled to the protection of the moratorium, and you could move forward with an eviction right now. But again, I want to be clear about this. You're going to have to prove all this stuff once you get in court. So don't fudge the corners, as they say, just to move it forward. If you've got the ability to go into court and prove the tenant was not impacted by COVID, then even in LA you could move forward. But let's assume they were denied because they made 85% AMI. Let's just assume that. So they really were impacted by COVID. They just didn't meet the income requirements, and that's why they were denied. You won't be able to serve a notice until LA decides to rescind or allow to expire the state of emergency.
All right, City of LA. Oh wait, that one we just did. Here we go. Current status in LA City eviction and rent increases. How about, you covered I think you kind of covered it on the LA City eviction, but maybe the rent increases?
Rent increases is pretty straightforward. If it's an RSO property, you're not permitted to increase rents. Non-RSO properties, you are permitted to increase rents in the city.
Okay, so Irvin on YouTube. Tenant received rental assistance for back rent. Tenant has stopped paying rent again. Can I begin eviction process now?
So this one, I'll just go the opposite direction and say, let's assume this is not the city of LA. If it's not the city of LA or a city that has a moratorium that prevents you from serving notices, the answer would be yes, you can move forward right now.
Great. So Tammy, again, guys, if you please put in the specific city that you're in and county, give us that information. It really helps us answer your specific question. And this is, again, it's not legal advice, right? You're just giving us
Correct.
Your interpretation of...
Especially on the questions, because there's so much missing information that I'm kind of shooting a little bit in the dark.
Right. So Tammy, one of my tenants took it upon herself and paid to have miscellaneous items to the dump. She did this without permission. Do I have to refund her the amount?
It's a unique question, but under what I'll call normal circumstances, no, you wouldn't have to refund her. I guess it would depend on what she took to the dump. So, and why she took it to the dump. But in general, no, if she made that decision to take some stuff to the dump, that's on her.
All right, here's a good one on YouTube. If someone sent in a COVID declaration for a month of April, do we need to take it in the city of Hawthorne?
No, because, well, actually, let me think about that. That's another good question. The declarations were assigned to notices that were pre-October 1st, 2021. So they're turning it in for April. No, you don't have to take it. City of Hawthorne is, I believe that's LA County, correct? And LA County, no, you don't have to take it at all. You've got that golden window right now that says you could just serve a 3-day pay or quit.
Right, and that's for the next 3 months.
Correct, 90-day window.
Yeah, the 90-day window. Here we go. Okay, Christine, status of rental assistance is pending for back rent before April 1st. Did not pay April rent. Can I evict? Yes, right?
Well, it depends on where you are. Again, same thing.
If they're in LA City.
If you're in LA City, for example, more often than not, the answer is going to be no. But so it'll depend on your city. If you're going to ask me about, can you evict, please put your city.
Yeah. Okay. If you have proof tenant is buying expensive things, can you start some process, notices, and eviction?
Yes. So again, there's still missing information. Let's just put that in the category of a jurisdiction like LA City that says you can't even serve a notice. Like I said, you're going to have to prove this. LA City's moratorium had that provision that says if you have a good faith belief they're not entitled to the protections, then you can move forward. And again, that's a paraphrase of what it really says. In that case, if you can prove they're buying expensive stuff and and it at least creates a reasonable belief that they weren't really impacted by COVID, then yeah, you can probably move ahead with that eviction. If you're in a jurisdiction that has no language or no prohibition against serving notices, then yeah, I would certainly serve a notice.
All right. Slippery on YouTube. Is there a provision in LA County unincorporated rent control that if rent is below market value, landlord can request rent increase?
There's generally a provision in most rent stabilization ordinances. All these ordinances all are premised on the basis that a landlord is entitled to a reasonable return. And to my knowledge, every rent stabilization ordinance has some process where a landlord can apply and claim that I'm not making a reasonable return, and I would like you to allow me to increase it greater than I'm permitted to do otherwise. Off the top of my head, I don't know if I'm conflating the city of Los Angeles with the counties. I know, like I said, I believe they both have it. So check the ordinance. If it's got it, start gathering your paperwork. I would be surprised if the county allowed you to increase it greater than you would otherwise be permitted, especially during COVID, since they're trying to extend their moratorium for 18 months. So they're really out to protect the tenants right now.
All right, James on YouTube. I have a condo in Gardena. The tenant is about $10,000 behind and has a rental relief application in process. Can I list the property for sale in the current situation?
I don't recall. Gardena is one of those cities I can never remember. Is that LA County?
Yeah.
Okay.
It's-
So can you list the property for sale? Yes, you can list it. Are you going to have some challenges with that? Yes, you're going to have some challenges because realistically, the challenge you'll face is that the tenant probably won't let you in to show the property. And the county's moratorium does not currently, well, you're under SB 2179 again. 2179, I don't believe has a prohibition on evicting for non-entry. And so I believe because the county moratorium has been pushed off for 90 days, under the state's moratorium, assuming that it is in your contract that the tenant has to allow you access to the property. If that's in the contract, then you could serve a 3-day cure covenant to get in and show the property. And if they didn't let you in, you would be able to terminate the tenancy.
Mm-hmm. And that's where we have two different types of AOA members. The ones that found out ahead of time, and they're nice and safe and snug with a good rental agreement.
Right, exactly.
And then those that found out after the fact, and here they are in a tough situation. So hopefully James, hopefully you're in a good situation. Ruzana on YouTube, what happened when a tenant is paid 18 months but still owes rent prior to March 31st, 2022?
So let me see if I can unpack that question and understand what they really meant.
So I think what they're asking is, can they get more than 18 months of rental assistance from Housing is Key or one of the other groups?
No.
And that's
it did limit it to 18 months. There was some talk that it said 15 months, but I seem to recall it being 18 months from when it went into effect. So you're not going to get more money from Housing is Key. So if they still owe you money, again, depending on where you are, what your moratorium says, if you have one, that may be a situation where you could actually start thinking about filing a small claims action.
Yeah, for sure. All right. Yeah, and remember, guys, there's also the video that we have with the representative from Housing is Key, and that was from last week. And they go into timelines on when you can expect to get your money, and just depending on where you're at in the process. And so that was enlightening. You can look at that one as well. Rick on YouTube, I own a SFR in LA City, rented to Section 8 tenant. Tenant is 2 months behind in her rent. I applied to Housing is Key on 3/29/21. Can I legally start eviction now, or must I wait until 2023 to evict?
Well, you cannot start. I've gone into the details enough times now. I think you understand where you could or couldn't do it. But under most circumstances, you could not start an eviction right now because of the moratorium. But as far as when you're going to do it, 2022, 2023, who knows? It's whenever the city rescinds that state of emergency.
All right, Rosa. Will I be able to evict a tenant that did not pay rent for the month of April? He has poker night from 11:30 to 6 a.m. I'm a mom and pop owner in East LA.
East LA falls under, generally East LA was going to fall. Did she tell me if it's a single family? No. So I'm going to assume this is a multifamily property. East LA falls under RSO. If it is an RSO property, it depends on how rowdy as far as the non-payment of rent, no, you're not going to be able to evict for the non-payment of rent. As far as the poker parties are concerned, the only thing that would fall under would be either he's violating a covenant, which would be a 3-day cure covenant, or it's rising to a level where it's a nuisance. And LA City is the one that's got that unique language about the nuisance that says no evictions for nuisance where they're related to COVID. So you have to kind of unpack that and say, well, is this related to COVID? Poker parties don't really seem to be related to COVID. So there's probably some scenario that if it's interfering with the quiet enjoyment of the neighboring tenants or it's causing some other problems, that there's probably some scenario that you would be able to evict under that.
All right. Erica, thank you. She wrote LA City. LA City, tenant no longer lives on property and has no personal property at the single family dwelling. She is now stealing appliances and fixtures from us.
So if she no longer lives on the property, you can't evict. That's what an eviction is all about. You're trying to get possession of your property back. So I don't know if there's at least two different ways I can interpret this. Either she vacated, but either her friends or family still live there and she's coming onto the property and stealing appliances from them, or she vacated and she's breaking into units and stealing appliances. If she's vacated, in general, you can't evict her. She's already gone. But obviously, you should be calling the police. If you have cameras, turn that over to the police. File a police report. If you don't have cameras, I'm not sure how you know it's her, but whatever, call the police. But essentially, if she's already gone, you can't evict her.
Right. Go to Costco, get those security cameras.
Ring cameras, exactly.
Get them put up there right away. And you know, we just suggest that for anybody, anywhere, because it's not just about catching tenants. This is about protecting your tenants and also diverting crime away from your property. And we had a video about that one, protecting your property, and that's another really good one to watch. But lights, camera, just not fun for people that are wanting to do things in the cover of night and steal and whatever else. So definitely make the investment and take care of it. All right, Ron, need to sell rental house in Lakewood. Tenant won't move out. What can I do? Tenant is now on welfare.
Lakewood's LA County, but the LA County moratorium has been pushed off. LA County takes the position that they are only preempted when it comes to non-payment of rent. I disagree. I think all of their moratoriums since August 19th, 2020 their extensions have been illegal, but you're still at risk. Like I said, that's a $5,000 a day penalty if you're violating their moratorium. There's a couple things that you could approach. Like I said, the moratorium's pushed off with regard to non-payment of rent. So you are subject to the moratorium. As of April 1st, the moratorium kicked in, and it talks about denial of entry. Right now, denial of entry in LA County, I believe, pretty much all denial of entry is protected in LA County. That I believe. I'm a little fuzzy on that one. But I think all denial of entry in LA County is protected unless there's a health and safety issue that needs to be fixed and the tenant won't let you in to fix the health and safety. So what do? All I can say is you try to work it out where they'll let you in to show the property. And if you can do that, then you can sell it. Otherwise, you can negotiate something into the deal where the tenant, I know you want to sell it as a house, and so most likely you'd be selling it to somebody who wants to occupy it. So even under the county's moratorium, as the seller, you can't terminate the tenancy for that. But on the back side, after the transaction, the buyer, who is now the owner, will be able to look at an owner-occupied termination of that tenancy down the line. So there are ways to approach this. It's just not going to be easy or fun for you, Ron.
Right. And one other thing, AOA does have a brokerage. AOA was actually a brokerage before it was an association. And so there are people, they can give a property valuation. And I say this not just for the person with that question, but just for anyone. We can give you a comprehensive property valuation if you're looking to selling. And anyway, we've been doing it for 40 years with the real estate brokerage. All the guys there have a lot of knowledge and experience, so you could definitely look us up on that. Think about us. Think about AOA Brokerage. Okay, Nick on YouTube. Does the current moratorium affect retail, commercial property in LA County?
Great question. Because all these state laws we've been discussing affect only residential. So then the question becomes, well, what does the county's moratorium say about commercial properties? And the county's moratorium came out and said that as of February 1st, there were no more protections for commercial properties. But I believe that commercial properties, like I said, I believe that they're not protected anymore. So I believe you can, don't quote me on this. This is one I'm going to have to double check. I know every time the county says something, different opinions come out about it. But I believe that the county acknowledged that as of February 1st, there were no more protections for commercial properties. And so, yes, I believe you can move forward on that one.
All right, Vincent in Laverne. 3-unit apartment, one currently waiting sheriff lockout time. Will we still be able to evict the tenant? It had a default judgment. Tenant got all 18 months of rent assistance already, but owes more.
So there's a lot of unanswered questions to this question. It's a good question, but I don't have all the information. I don't know. When you say tenant got all 18 months, but owes more, is the amount that they still owe the basis of the judgment? If it is, and that's what the eviction was filed on, then yes, you will still be able to move forward with the lockout. I do want to take this opportunity to say, though, there was an article that came out just yesterday, I believe it was, in the San Francisco Chronicle, about the Department of Justice has issued something like 150 letters to different attorneys around the state. I have not received that letter, but it did. The issue that the Department of Justice brought up is that on these default judgments, be careful what you're signing. You are signing those under penalty of perjury, and it's been brought to the attention of to the Department of Justice that many of these landlords have signed these declarations when there's verifiable evidence that the tenant had in fact notified the landlord that they had applied for housing as key. And in that case, the court is not supposed to issue a default judgment. In your case, it looks like they got all 18 months, and so I think you're probably safe with that. I wouldn't worry about it too much, but again, if you're only talking about the unpaid amount that they didn't receive, and that's what your eviction is based on, I think you're going to be fine moving forward.
All right. Lou, how can we serve the 3-day notice to pay rent or quit, rent due from October 1st, 2021 to March 31st, 2022? Should we change the wording to match the AB 2179? Do we change the date to October 1st through June 30?
I'm going to assume you are not in LA City, for example, that prohibits this stuff, but no is the answer to your question. You're going to have to serve multiple notices. So for October 1st through March, oh, wait a second, hang on a second. Let me make sure I'm reading this correctly. Rent due from October 1st. Should we change the wording to match? No. I see what you're saying now. For October 1st through March 31st, it's a very specific notice. That's all you do. You do not change the wording to match AB 2179 because 2179's wording only applies to rent that became due on or after April 1st. So don't change the wording.
Okay, that's actually a really good question because
Yeah.
when you read the bill, it talks about you need this kind of wording for
Right.
these different periods.
Right.
And
that's really important. Again, I touched on this earlier, but the period of time that you're seeking the rent for, whenever it accrued, will determine which notice you need to serve. Mm-hmm. So don't try to do this yourself. Hire people who know, okay, you're looking for rent for this period, that goes with this notice. Don't try to figure out, based on the bill or the law, what language to put in these notices.
All right, Hermosa property, City of LA, RSO. The year lease ends in May. Tenant is a pain. I want to terminate the lease before the year lease is up so he will move out. With the protections, when would he have to move out?
So you're under RSO, so they're protected. You're in a fixed term lease, so you can't terminate the tenancy until the end of May. And even at the end of May, you're not going to be able to evict them just because they're a pain, because you're under RSO. So the protections are irrelevant right now. He doesn't have to move out. He or she doesn't have to move out at all. They are protected by LA's rent stabilization ordinance. But one thing I will say to you is, at the end of this lease term, I would approach them and force them to sign a new 1-year lease. I'm assuming this is the first year that they've ever been there. So you're coming to the end of your lease term. Most rent stabilization ordinances state in there, if you're at the end of your fixed term and you approach the tenant and with a substantially similar lease and the tenant refuses to sign it, that would be the basis of an eviction. So I would do that. I would approach them and say, hey, I've got your new 1-year lease to sign, and if they refuse, assuming that the ordinance allows for that, I would use that as a basis for an eviction. But otherwise, they're protected. They're not going to have to move out.
All right, Michelle Short, West Hollywood landlord. We're part of LA County, but
They're following the state, not the county.
yeah, rent stabilization told me yesterday we're following the state moratorium, not LA County.
Right.
So can a tenant self-certify, or is rent required?
So you're following the state. For any past due rent, self-certification, let's explain what that means first. It means when a tenant has been impacted by COVID, the tenant just has to notify you, hey, I've been impacted by COVID, and that satisfies the requirement. The state law does say that tenants are required to notify the landlord within 7 days, I believe it is, that they've been impacted by COVID. And that's a form of self-certification. It's not as burdensome as LA counties, but this goes back, even West Hollywood acknowledges that because they're in the county, they actually have to follow state law. So now it gets down to, so what period of time are we talking about? If we're talking about the COVID rent, yes, self-certification would meet the state's requirements. But if we're talking about April 1st rent, then there is no self-certification. You've got a golden opportunity here for 90 days. If the tenant isn't paying rent April 1st and afterward, you serve the 3-day notice for non-payment of rent that's required by 2179, and self-certification is a non-issue. Just move forward with the eviction.
All right, Darius on YouTube. What is the latest on that bill where landlords can get paid if tenant isn't cooperating?
The last I heard, that has not been voted on. It is still in play, last I heard. And so, it's a pretty popular bill. And just to clarify what Darius means, there is a bill up in Sacramento that says if a landlord gets denied from Housing is Key, or somehow doesn't receive the rental assistance funds, that they can obtain a grant from the state for those funds that they didn't receive under Housing is Key. So that is a popular bill, as you can imagine, and so it is still in play, last I checked.
Okay. Ginger, please give us where you're at and everything, but can we charge late fees? Let's assume, since this is mainly for people in LA County.
No, no late fees.
Can you have a late fee?
I would actually argue that
April's rent, you could, right?
I was just trying to work through that in my head. Even the state's moratorium, I believe, again, I have so many moratoriums floating around in my head, it gets hard to recall them all without the book right in front of me. But I believe the state even says there's no late fees on unpaid rent. But as of April 1st, if you're under the state's control, then yeah, for April you could charge late fees because their law expired. Yeah, that was not one of the protections that was extended. Their law expired March 31st. So for April, assuming that you're under the state's control, yes, you could charge late fees.
Yeah, and you're not LA City.
Right. That's why I mean when I say you're under the state, yeah. If you're not LA City or LA County, I believe April 1st, you can charge late fees. Anything prior to that, you cannot.
All right, Benjamin on YouTube. My property is in the city of LA under RSO. If tenant does not pay April rent, can I serve 3 days notice, pay or move out?
No. Under most circumstances, the answer is going to be no.
Rental Housing Association of South Alameda County. So, will small claims court have a limit to how much you can file a claim for? Some owners are due as much as $50,000.
No, it will not. Under the state laws, there is no cap. They actually changed the small claim rules for COVID rent, and there's no cap at all. It can be $200,000.
And you guys come on out for Thursday, and you'll get more questions answered. South Alameda. All right, YouTube, Michael and Hawthorne. We have a tenant who refuses to connect our landlord ID to his case and hasn't paid us anything from an earlier award he received without putting any landlord info in. What do we do?
So Hawthorne, you're in the county of LA, and you have a tenant who's not cooperating with Housing is Key. They're not protected. You can serve all your notices for COVID rent, your back COVID rent. You can serve all of those, and even if the tenant gives you a declaration, I would say move forward and get to court and let the court make a decision about what they want to do. The court's going to order them, even if they do file their declaration, the court's going to order them to pay you 25% that they were supposed to pay under the state laws. And the fact that the tenant hasn't paid you anything from an earlier award that he received without putting the landlord information into it, I think that would be a situation where I would probably bring some type of fraud action against him in small claims and go after the money. And it doesn't even have to be small claims. You could probably file that in civil court and go after him for a judgment, and again, use that as leverage to negotiate some sort of a tenant vacate agreement. And
there's also, with the housing is key, you can, you need to report that. I think it's report fraud at, I can't remember what it is. So go on their website and housingiskey.com and just search report fraud, because they have an email address where you can just send that information to them, because they are, when they get the time, they're going to get around to it, and there's going to be some people that are busted, both tenants and housing providers. So definitely stay down the straight and narrow, but let's bust people like this. They need to be held accountable.
I'd like to just add to that, Jeff. I know for a fact that they have gone after tenants who scammed the system. So yeah, I would definitely turn them in. You're absolutely right.
Yeah. All right, Valencia, RS location. I'm not sure if they mean RSO or what they mean there. Condo unit not subject to AB 1482. Lease expired January 2022. Does AB 2179 mean I am now allowed to move back into my own home? If so, how much notice do I need to give tenant?
So Valencia is LA County. It's not subject to 1482, so normally you'd be able to do that. But remember what I said, that LA County has taken the position that they are only preempted when it comes to non-payment of rent. Their position is that their moratorium controls. So even though we've got 2179 right now, the county would tell you that no, you're not allowed to do an owner-occupied right now unless you meet certain requirements. So, and they admittedly, they have diminished the requirements for owner occupancy, and you may be able to meet those requirements. This is one where I would encourage you to call my office and we'll walk through what the requirements are, and if you meet those, the answer is yes, you would be able to terminate the tenancy. And how much time would you have to give the notice? It'd be a 60-day notice. But I believe, again, don't quote me on this, but I believe LA County is one of those moratoriums that said if you use the owner occupancy portion of their moratorium, even if you meet the criteria, you may have to pay those tenants the relocation fees that come up under the county's just cause eviction ordinance. So, like I said, call my office, and that's one you should talk to me directly or an associate, so we can do the research and figure it out. But I think you're limited right now.
And also, that isn't that one where you have to, if the person in the home is over 62, then you have to be over 62.
Yeah. Exactly. That's what I mean. They've got this criteria you need to meet, and they have diminished it. It was even more stringent several months ago, but even though they've diminished it, you've still got to meet this criteria. Now, it looks like she's in Valencia, so I believe Valencia is incorporated, so that normally would not fall under the county's just cause eviction. So it may make sense for her to wait so she doesn't have to pay those relocation fees, because right now the county would tell you, you fall under our moratorium, and that means you have to meet this criteria, and I believe, like I said, I believe you have to pay the relocation fees as well.
Right, okay. Dimension 79. Can we reserve all of the notices?
You can, and it may not be a bad idea. If you intend to serve a notice for April, anytime you serve a notice, think about a notice for a second. What do we call those notices, especially non-payment? They're called pay or quits, right? That actually, there's a reason the or is in there. It comes from the law. The law says you have to state those notices in the alternative. In other words, pay me what you owe me, or, that's the alternative, quit the property or get off the property. What happens when you serve a pay or quit notice and then you serve one subsequently, you actually knock out that first notice. That notice is now ineffective. So if you're thinking about serving another notice, for example, like a notice for April, you will knock out all your previous notices. So serve all of them again, and wait the required time periods and go to court. And like I said before, let the judge hammer it out, right? If somebody's going to make the allegation that, well, these COVID rent notices aren't effective anymore, fine, let them make that argument and let the judge hammer it out based on the statutes. But you'll still be left with your April 1st notice, and you'll be able to proceed. A judge, if you serve multiple notices and file the eviction based on all of those notices, a judge can kind of do what they want. They can knock out notices that are defective, and they can allow you to move forward with notices that are not defective. So serve them all.
Mm-hmm. There we go. That's actually a good question.
Yeah, that was a good
lot of the questions are good. When I say actually, I mean like.
Yeah, it's one that doesn't come up a lot.
Yeah. So that's great. Okay. If I was to sell my property, is there a relocation cost to LA County?
If you're subject to so selling the property, well, you could always sell your property with the tenants in it, and then there would be no relocation fees. And also, it would depend on whether your property is subject to the county's just cause eviction moratorium. So if it is subject to that, and you sell it with the tenants in it, no relocation fees. If it's subject to the rent or the just cause eviction the just cause ordinance, and you're trying to evict the tenant first, assuming you have the right to evict the tenant, then yes, there would be relocation fees involved.
All right. City of LA, April 2022 and on. There's no housing is key. What happens now? We had a video with that title pretty much last Thursday. You'll want to hear from, I believe, Lori was her name, and she answered a lot of questions and gave good background. Watch that video for sure. But basically, we covered it already where we said because there is no housing is key, now you can proceed with evictions for non-payment of rent.
City of LA?
In LA County.
In LA County.
And in the state. So,
right, but not in the city of LA.
But not in the city.
City of LA has their moratorium, which we have covered multiple times.
Right.
Most likely, no, you're not going to be able to move forward on that.
Right. Okay. In Riverside County, covered by the state law. Oh, is Riverside County covered by the state law?
The short answer is yes, but remember what I said. The state laws don't extend everything through July. They only extend the protections to the people who have already applied for housing as key. So if you've got a situation in Riverside where the tenant has not applied for housing as key and they didn't, and you're seeking rent, then they wouldn't be protected. Or if you're seeking rent for April 1st only, they wouldn't be protected.
Right, and Riverside's pretty reasonable. I don't think they have an eviction.
No.
They don't have their own policy.
They don't.
So,
Riverside, San Bernardino, it's like Mecca.
Right. It became the new hot place to buy property,
yeah,
right?
Exactly.
David on YouTube. When does the City of LA emergency end?
Great question.
May 1st, 2023 or sooner?
So I have no answer for that. Yeah. I have no idea when their state of emergency is going to end. Yeah. I will say that it's getting harder and harder for municipalities to justify the continuation of the moratoriums or the states of emergency. But I've seen many many municipalities really, like I said in the beginning, there is definitely an advantage to some groups continuing this as long as they want, as long as they can. And it appears that the County of LA and the City of LA want to push these out as far as they can.
All right, Armando. How does the tenant prove that notification was given to the landlord? If self-declaration indefinite or has to be given each month? City of Downey.
So Downey's under the county, and believe it or not, this is one of those little nuances. All of the moratoriums, to my knowledge, require the tenant to provide the landlord with notification that they've been impacted every single month. It isn't just a one-time and done. Mm-hmm. Now, how do they prove the notification was given to the landlord? They're going to have to go to court, and that's what we call an issue of fact for the trier of fact. If they have a text message, then that's easy to prove. If they say, I just told the landlord, and I told him the first week in April, and the landlord says, well, I don't know how you did that. You don't have my cell, and I was on vacation in Maryland the first week. Then, then there's a hole in their story. So all they have to do is go to court and have admissible evidence to prove that they gave it to the landlord. No, it's not. Self-declaration, like I said, is not indefinite. It has to be given each month. And if they don't give it for a month, guess what happens? They're not in compliance with the moratorium. Move forward with the eviction. But City of Downey, you're not, the non-payment of rent issue isn't even, doesn't even come into play for the next 90 days, at least on the county level. It only comes into play with the state. And even the state requires the notification to the landlord.
Right. Yeah, and out of abundance of caution, there's that whole 7-day, it's a 7-day period where they have to self-certify, right?
That's under the county's moratorium.
Right.
But the county's moratorium isn't in effect for 90 more days. Or at least the non-payment of rent component is preempted until the expiration of 2179. So that's a question. You're saying, I like the phrase you used, out of an abundance of caution. My personal belief is, from a legal perspective, they don't have to wait the landlord doesn't have to wait the 7 days. Mm-hmm. If rent's due on the 1st and the tenant hasn't paid you, on the 2nd, you can serve the 3-day pay or quit. But because the county's moratorium says the tenant has 7 days to notify you if they've been impacted by COVID, out of an abundance of caution, if you want to wait till day 8 ticks around before you serve that notice, there's no harm, no foul to doing that.
Great. Chris on YouTube. My LA RSO property, I have tenant that got HIK funds in August but won't do it again. Didn't pay April. Can I evict?
So this is really interesting. This is one of those great fact scenarios that I'd love to talk to Chris about.
Yeah.
So maybe they were impacted initially by COVID, and that's why they got their funds in August, right? But maybe their impact went away, and so now they're no longer impacted, and they won't do it again. Why? The city's moratorium prohibits endeavoring to evict, which includes the service of notice. But where a tenant refuses to apply, well, it's too late now, but let's assume they could. Where a tenant refuses to reapply for those months, I think it's a reasonable assumption that the reason they're refusing to apply is because they know that their impact was gone. They're not going to get approved. They just weren't paying rent. So to me, that's scamming the system. Mm-hmm. And if you're scamming the system, you're not entitled to the protections of LA's moratorium. And that's one where I would say, look, if you've got some good way to prove it, like the tenant put it in a text message, no, I'm not going to apply, I'm not going to reapply, I would say let's move forward with that eviction. And force the tenant into court to demonstrate that they really are impacted by COVID after that August.
Great. All right. Denisa, is the landlord required to participate in Housing is Key program if the tenant applied for it?
Doesn't even matter if the tenant applied for it. If you want to evict, you were actually required by AB 832 and all the preceding laws to file your application with Housing is Key before the court would even issue a summons. And if you didn't file with Housing is Key, you weren't getting a summons issued. So yes is the answer. Every landlord owed rent was required to apply with Housing is Key.
All right. Can Mr. Brennan give landlord a decision tree?
Yeah, you wish. Absolutely not. It's just too complicated. There's too many moratoriums. There are too many nuances. And then you have to, even if you think you've got a handle on the laws, then you've got to apply those laws to specific fact situations. And every fact situation is different. So believe me, every one of my staff members and associates wants a decision tree. I cannot provide that.
You'd have to, the file is so big, it's
exactly.
Like, it's this big.
I don't even think my internal computer could process all of the variables.
Because we totally tried to do that, and then it was just like, for all the counties, for all the different situations in every single county, it just becomes crazy.
Yeah, it's just not possible.
So yeah, Allison, all right. Clara, what happens 90 days from now?
There's an asteroid that is projected to hit the planet. No, I'm kidding. We don't know. And that's what Jeff and I were talking about before the webinar got started. And I think I even mentioned this during the webinar. 90 days, the county's moratorium is going to kick in. as of today, that's what the law will say. What version of the moratorium is going to kick in? We don't know yet. They have 90 days to amend it, to change it. They could come up and say, and by the way, I'm assuming that we're talking about LA County right now, but let me answer it for LA County, then I'll answer it for all other places. We don't know what's going to happen for LA County. We don't know what moratorium version LA County is going to try to implement on July 1st. I suspect they're going to change it. For all the other places, what's going to happen in 90 days is theoretically SB 91, what is it? 20, I forget that.
2079?
Or 2179, right.
Yeah.
SB 2179 is going to expire. And if you're in an area like Riverside or San Bernardino County that have no moratoriums, you're going to go back to the glory days of pre-COVID. It's a regular 3-day notice. They don't pay within the 3 days. You're going to file your eviction and work through the system. If you're in an area with a moratorium after the 90 days, you're going to have to look at that moratorium and navigate through the moratorium's requirements.
Great. And let's see, how's Burbank affected?
Burbank falls under the county.
Right. David, how do you prove a tenant has not applied for rent relief?
By 3/31. So if the tenant had applied, you would, in most cases, you would receive an email from Housing is Key that would say, hey, your tenant's applied. And I'm assuming, David, that you have applied. If you've applied, you've gotten your email back saying, hey, we acknowledge receipt of your application. If the tenant has applied, they will try to link those. If the tenant has not applied and you have something like a text that says, I refuse to apply, that's how you prove it. If you don't have anything and the tenant told you they applied, but you don't believe they have, what I would recommend is you sit tight right now because, one, they could be telling the truth, and their application hasn't even been assigned a caseworker yet. And that could be why you haven't received any sort of an email. Two, I don't want you to run afoul of these laws. Unless you can really prove it with some concrete evidence, sit tight and see if you get an email from Housing is Key. Depending on what jurisdiction you're in, it may not matter. If you're in a jurisdiction that doesn't have a moratorium, then April 1st, don't worry about whether they applied for rent relief or not. Serve your 3-day notice for April and move forward with an eviction based on that.
Great. All right, well, I think there's a ton of questions left there.
I think we could go all day.
Yeah, we could go all day. But anyway, thank you for joining us. And I know that there's tons of questions. You can give his office a call. So thank you. And also, definitely please give to the AOA Political Action Fund for the lawsuit that we have. Also, remember to send out that letter. There's a lot of stuff to do, right? Sending out that letter about the whole covering up the credit reports, all the background checks. If you don't want to be blindfolded when you pick your tenant from among several applicants, then you're going to want to send out that letter or something like it to your city council members, the county board of supervisors, all of your representatives. You're going to want to make your voice heard on that for sure. And don't forget to sign that petition for the repealing the death tax and with Howard Jarvis. So come into the office and do that. We're definitely here in the Van Nuys office. Some of the other branch offices, if we have somebody out sick, the service hours may be different. So just call ahead before you go just to make sure that someone's in the office. Like I know we have right now, our Wilshire office, we have somebody out right now. And so just call ahead for sure. And then this Thursday coming up, we have the Northern California legislative update, plus that how to increase, get 67% more exposure to of your property when you're trying to lease it out, and how you can do that for free. So catch those. And anyway, really thankful that you're with us and that you're trying to do the right thing, that you're a constant learner, and we love that. So we'll see you real soon. Take care.
Thank you. Jeff.